Hey everybody, I am Tiffany Weber. I am a real estate and estate planning attorney in North Carolina. We have 3 offices around the Lake Norman area, and today I'm here to talk to you about estate planning for parents and talking about how to plan for the different stages of parenthood when it comes to your estate and providing for your children after you are gone. Now, I've been doing real estate and estate planning in North Carolina for 8 years and have helped a lot of families get their plan in place to make sure that they're comfortable and confident that when they're no longer here, that their children will be taken care of in the way that they choose. So let's dive right in. First, it's really important to know that despite it being morbid to think about what happens when you pass away, it's an essential part of planning for your future. And if you are anyone that has experienced the loss of a loved one or a friend, or someone that did not have an estate plan, and you had to go through everything that's required in order to make sure that their intestate estate was carried out, you know that it's difficult. It's not necessarily that it's easier to lose a loved one when they have a will, but all of the administrative tasks become much easier, and you have much more clarity about the desires of the deceased and who was meant to be taken care of with certain items, money, property, etc. So when you're a parent, I'm the parent of a 2.5-year-old, your perspective changes a little bit, right? So I've told people that, before my daughter was born, I didn't really fear death. And now that she's born, I do because I just want her to be okay. I want to make sure that she's taken care of. I want to make sure that she's, loved. A will can't do that, but you can designate guardians that you believe will take care of your child the best possible in your absence. And then making sure that she has all of the money and resources that she needs to live a full, happy life and have all of her needs met. So that's something that I didn't really care as much about prior to her birth. We had a will, we had all of those things carried out, but it packs a little bit more of a punch when you have these little ones that you want to protect. So, that's with most parents that come to our office, the number one thing the reason they're even sitting in the chair at our conference table is because of their children. So let's think about why is estate planning essential. One, preserving assets for your children. Like I mentioned, making sure that there's money there to take care of their education, support, health, maintenance. Avoiding family disputes is another one. We don't want to think about what happens, if you pass away, that your family is going to be arguing over your things. But unfortunately, it's a reality for many people. And if you provide that clarity in a legal document that with a legal requirement that it be carried out the way that you intended, then the goal is to minimize family disputes. And one person saying you told them this and the other person saying you told them that. The document is what is going to control. And then also making sure your wishes are honored. So not just disputes, but perhaps you said you wanted to be buried in a certain place. That's something that you can state in your will. Perhaps you wanted a particular item of sentimental value to a certain person to be given to them. You can tell the person that you want to carry out your estate, please give that ring to this granddaughter. But there's no overseeing, there's no requirement for that person to do so unless you have created an estate plan that, again, makes that legal requirement. And also peace of mind that you're setting aside money to pay for any potential estate taxes, trying to make sure that the transition of funds from one generation to the next or from you to your beneficiaries is as smooth as possible. Now let's talk about the components of an estate plan. So an estate plan, they can be simple, they can be complex, they could be middle of the road, but there are some essentials that in fact, we call them the estate planning essentials in our office if you're coming to get a consultation. And that would be, your primary document would be either a will or in most cases, a revocable living trust, meaning you maintain control over it during your life. Irrevocable, there's less control. That means someone else is making the decisions and you don't have control over the assets, but revocable, you maintain complete control. We'll talk about asset distribution. It'll address guardianship. A living trust can do those same things, except, it's slightly different carried out. You can discuss guardianship arrangements for minor children. North Carolina even has a statute that allows for designation of standby guardianship. So there's a document that can handle that. That can be part of your estate plan. Then your different powers of attorney. So this would be, could be a durable power of attorney, or it could be healthcare power of attorney. And then also your healthcare directives. So that could be, healthcare power of attorney could address some of that, but then a living will, or as we like to call it by its official name, advance directive. Living will can be kind of confusing for some people. They'll sign a living will, which talks about your end of life choices while you're still living, but they think they have a will and they don't. So they've missed a key component of the estate plan. So for that reason, I'm going to refer to it throughout this presentation as an advance directive. You may know it as a living will. That's okay. We're talking about the same thing. So one of the biggest questions we get in our office as part of estate planning is, should I do a will or should I do a trust? And one of the analogies that I will often use is, will is kind of like a crock pot. You can set it and forget it for a little while. A trust is a little bit more like French cuisine. It's got to be monitored. You got to stir it. You got to check on it way more frequently if you want it to come out right. So, a crock pot, you can get some tasty food, mostly hands off. A trust, way more hands on. So the components of a will, as mentioned before, is going to talk about asset distribution. You can name a guardian for minor children. You're going to list your fiduciaries. So fiduciary is a big word for someone who has now a legal duty to you. So they're required by law to look out for your best interest and carry out the things that you desire. Again, provided that those things are legal and in your best interest. So an executor is the person who now has a legal duty to carry out the terms of your will, should they accept. In North Carolina, a person can renounce their right to serve in that capacity. So if you've appointed someone who maybe at the time of your passing is not in the best condition to serve, they can renounce. That's why we recommend appointing backups as well. Other types of fiduciaries, guardians, trustees. Now, when it comes to maintenance, yes, it's more set it and forget it, but no, at some point with a crock pot, you still have to check on it. You got to turn up the crock pot so that I digress, but I once ruined a crock pot because I left it on too long. So yes, they can be ruined. Same thing with the will. If you make it at one point in your life and you go through a bunch of changes and you don't own any of that property, you don't talk to any of those people anymore, you haven't provided for children, it can become, virtually ineffective. So it's not maintenance free, but it is lower maintenance. And then as far as administration goes, the administration of your will involves probate. Probate, some people think is a dirty word because they have associated probate with fighting, with disputes, with people who didn't have a will and it was extremely complicated and drawn out and cumbersome. Probate does not have to be a dirty word. It doesn't have to be overly complicated, especially with a well-crafted estate plan and an executor that's diligent. But probate is simply just the orderly administration of the things that you want done. Now, when it comes to a trust, one of the key components or key differences between a will and a trust is a will is a legal document that gives directions, and a trust is a legal document that creates an entity known as a trust, but that document gives the direction. So think about, like, if you're familiar with LLCs, in an LLC, you've got the document, you've got organizational documents. So they're created by a document, and then you have an operating agreement that tells you, this is how we're going to run this thing. This is who's in charge. This is what they're allowed to do and not allowed to do. This is what happens if we have to get rid of that person. It tells you everything you need to know. Well, a trust being a legal entity, meaning it can own stuff, it can have bank accounts, it can sell stuff, etc. Just like an LLC would, the trust document tells you who's in charge of this thing, what are they allowed to do and not allowed to do, what happens if we need to replace them. So that is one of the biggest differences between a will and a trust. Is a trust becomes a legal entity once it's funded, and it can own stuff. It can own your house, it can own your cars, it can own all kinds of things. Now, as far as I mentioned funding, your trust is useless until it's funded. So that's either by putting some assets into it. A lot of people will make that their real estate. They'll put their real estate into the name of their trust. They'll title their cars into the name of the trust, bank accounts, etc. It's important to know that you only, trust, you can avoid probate, but only to the extent that your trust owns what you own. If your trust doesn't own those items, then they become part of the probate estate. So it's really important. That's why I mentioned trusts require more maintenance. As you come to own and sell and convey and transfer things, you got to make sure that the trust is covering all of those things, or else those things will become part of your probate estate. So whenever you're trying to decide between the two, you're not just talking to an attorney here. You need to consider other professionals that you seek advice from, particularly a CPA or tax attorney. You're going to want to talk about, what are the tax implications of this? What's the benefit? What are the drawbacks, if any? Really, what is the best for my unique situation? I can't look at this camera right now and tell you in all cases, this one is going to be better for everyone. It's just not true. There could be people where a will makes the most sense for them, and people where a trust makes the most sense for them. But you only know by talking to your professionals and giving your specific scenario. Now, let's talk about the kids. When it comes to choosing a guardian for your children, this is probably the most emotional part of the estate planning process, is having to confront a potential reality where someone else other than you is caring for your children. And it's not easy. And, I won't pretend to you that it is. It's going to be your least favorite part of preparing your estate documents. But at the end of it, you're going to feel more calm and comfortable knowing that you have planned for this and that you're not leaving chaos in your wake. So when you're thinking about a guardian, you may want to think about someone who is most likely to parent the way you would, in the way that you want your child parented. So that could, you got to consider values. Whether you are a member of any particular religion, is that important to you that the child be raised by someone of that same faith? If it's not, then, you can take that out of the pile of things to consider. The location, where does the person live? Perhaps you want the child to be raised in a certain area. So if the person doesn't live in that area, then maybe you don't choose them. It could be whether it's really important to you that it's a family member. If that's the case, then you're going to want to consider, of those family members, are they in the location you want? Do they have the values? What's their parenting style? I don't know all the names of the different parenting styles, but we can observe, go to any restaurant where there are kids present. You can see all the different parenting styles on display. So those are all things that you need to consider as a threshold matter. But most importantly, is that person willing to serve? So if you put all your eggs in one basket and you designate somebody that's not willing to serve, you may have an issue. So, just like with executors, we want you to consider backups as well. Now, the legal requirements, anything when it comes to children, a court monitors carefully. So the court in North Carolina will give major deference to the wishes of a parent when it comes to their child after their passing. But in your absence, the court is going to oversee to make sure that this is in the child's best interest. So there could be proceedings in which the guardians that you've chosen get a legal appointment as the guardian, and then will be allowed to, handle finances, healthcare, do everything that you would have done were you still alive. So just understand that think about, if you want to appoint someone that maybe has a complicated legal past, think about what's going to happen if a judge may look at this scenario. Are they going to be concerned about this person's past, that it's not in the best interest of the child? Think about health conditions, where it may be difficult for someone to, give a child the attention that they need and deserve. So consider all of those things that, your wishes are of paramount importance, but then you also have the safety net of the courts to make sure that things are being done in the child's best interest. Now, we've talked a little bit about probate already, but in probate, it's the orderly administration of your estate. It's also validating your will, making sure that it's yours, that it wasn't forged, that it was properly witnessed, There are some wills that don't have to be witnessed. It's a holographic will. Essentially in your own, there's all kinds of components, but if you think of a handwritten will kept in a really safe place and signed by the testator. If you're making a will, you're called the testator. That's one type of will. The other is like your typical drawn by an attorney, notarized and witnessed. So that the probate process also validates your will and says, yes, we're accepting this as the final wishes of the person that passed. Another thing to think about in probate, I mentioned earlier that it could be chaotic if a person doesn't have a will. This is the difference between testacy and intestacy. And those are big words, or, not necessarily that big, but legal words that mean with a will, testacy, or without a will, intestacy. And without a will, it's often confused. People will say, well, I don't want my stuff to go to the state. I don't want my stuff to end up the property of the state. That is extremely rare. Intestacy does not mean that your property goes to the state. It means that it goes to your heirs at law. And there is the statutes talk about who your heirs at law are, but I'll give you an example. Let's say you are a married person and your parents are living. You don't have a will. You pass away. The current state of North Carolina law would be that half of your estate goes to your spouse and the other half would be split between your living parents. As a married person, maybe you don't want that. Before I had children, not what I wanted. I wanted everything to go to my spouse. So we created a will, not knowing if we ever would or could be able to have children. We wanted to get our plan in place. So we got our wills together and I wanted to make sure everything was going to my spouse rather than being split between him and my living parents. So that's one way that intestacy could carry out. Or let's say you are someone that has a spouse and living children. Then it could be half to spouse, half split between your living children. That might be okay with you. So, consider what the laws of intestacy are. And if you're just fine with how that is handled and what the state has decided for you, you might be okay. But for most people that I talk to, they don't want the state to decide for them. They want to decide for themselves. And a will does more than just say what percentage is belonging to whom. Now, a lot of people let me go back to the other slide. Avoiding probate, you do that by your trust owning as much as possible, everything if possible that you own. Because a trust once it's owned by the trust, it's a non-probate asset. Another type of non-probate asset would be real estate that you own as joint tenants with rights of survivorship, or as tenants by the entirety, meaning as in North Carolina, that means as husband and wife. So that would not go through probate as well. It would immediately belong to the survivor. So if your property is owned by the trust, then the trust terms control and you don't have to go through the court to do that. Now, it's often recommended in our office. We recommend always to have what we call a pour over will. So even if you've chosen a trust and that's what you're going to do to manage your estate, we recommend that you have a will called a pour over will that says, anything I own that's not already owned by my trust, I devise it to the trust. I'm giving it to the trust. And that's the way to get the trust to administer, everything or control the terms of your estate. You still have to probate that pour over will. So that's why it's incredibly important, if you want complete probate avoidance, to make sure every asset you own is owned by the trust or is otherwise a non-probate asset. Now let's talk about common mistakes to avoid. Failing to update your plan. Like I mentioned with the crock pot I broke, same thing with the will. If you decide that you're going to give everything to cousin Donna and then you'll have a falling out and you never want to see or speak to her again. If you haven't updated your will at the time of your passing, then cousin Donna is still going to get what you said all those years ago. So that's one issue that could happen where you're failing to update your plan. Or let's say you've named guardians who maybe unfortunately have passed away or they're incapacitated and they can't care for children. All hope is not lost. The court's still going to step in, but it makes it more complicated. So updating your plan to make sure it's current, prevents issues like that. And then not planning for incapacity. It's really important to consider how your estate plan can be useful for you during your life. In the real estate portion of our practice, we'll have people call and say, I have a power of attorney for my dad, and he passed away, so I'm going to sell his property. Power of attorneys are for the living. Wills are for the dead. But a power of attorney can be so powerful as part of your estate planning because of incapacity. Incapacity could be you are injured and can't make decisions for yourself. It could be a loss of lucidity. It could be, an issue with brain function. It could be Alzheimer's, dementia, something that prevents you from being able to make legal decisions on your own behalf. And here's the thing. If you can't make legal decisions on your own behalf, you can't enter into legal documents either. So if you don't make a power of attorney while you have capacity, you're not going to be able to make one. So a power of attorney has to be considered prior to incapacity. It's one of those things where the best time to make a power of attorney is when you don't actually need it. So healthcare power of attorney, you're making it, while you're presumably healthy and full control of your faculties, and you're setting forth for your healthcare agent what you want to happen when you can't make those decisions for yourself anymore. Same thing for your finances or your other matters. A durable power of attorney, you can tell your agent, if I'm not able to do this for myself, these are your boundaries. This is what you're allowed to do. This is what I want you to do. And so those can be incredibly, incredibly important for during your life, during periods of incapacity. And remember, incapacity doesn't have to be forever. So let's say you regain capacity, you get right back in control of everything. It's not as if once you are incapacitated, those powers of attorney take over and you're done. That's not true. And then finally, not planning for minor beneficiaries. If you give real property to a minor and that minor needs the property sold for one reason or another after you've passed away, maybe it's because they need money to be able to pay for health care, education, etc. A minor can't just up and sell property. So they've got to get the court's blessing. A guardian's got to be appointed, a legal guardian beyond just physical care of the minor. So legal guardian over their affairs. So one way to tackle that is within your will, even if you don't get a trust, you can create a testamentary trust, meaning once you pass away is when, and certain conditions are met, is when the trust is created. So if I'm recalling correctly from my own will, it's been a little bit since I looked at it. If I pass away and my spouse is not living, then and then my child is under 18, then a trust is going to be created for her in which she receives, portions of her inheritance in well-spaced intervals. A trustee has been named to manage those things for her and make sure that she gets those distributions at the right time, and also is able to use the funds to pay for her healthcare, education, maintenance, support, to make sure her life is good. So that's another way to plan for minor beneficiaries in your will, even if you don't create a trust. Now, of course, any party can create their own document for themselves. Unfortunately, that doesn't mean that it will be carried out the way that you want. So, you might draft your own will. You're entitled to do so. You can't do it for someone else unless you're a licensed attorney in that state. So you can't practice law for somebody else, but you can prepare your own document. The heartbreaker comes when you have prepared your own document and you have missed something, or you thought you explained it, but it was not clear, and it creates division or litigation among family members because your document's not understood. So that's where we come in. That's, we train for this. We've reviewed case law and what's the bad stuff and what's the good stuff. Nobody is perfect, but the point of having an attorney is to have someone in your corner who is helping you prepare a document that's going to be carried out. And I've heard another estate planning attorney say this. He says, you don't really care about these documents so much. You care about that what you want to be true when you pass away happens. And that's what the estate planning attorney can do for you. The other thing is involving your financial planners and accountants and tax professionals. So if you've got a tax attorney, you've got a complicated tax situation, there's probably going to be a specific structure that's very important for you to minimize tax implications. So like I mentioned before, you're not only talking to an estate planning attorney when you're doing this. You should be talking to your accountant. You should be talking to, if you've got an advisor that's helping with your investments. If again, tax attorney, that we've got to minimize effects of, let's be real, nobody wants to pay more taxes than they legally have to. So that's the importance of involving other people within this planning scenario. Now, this is what you need to do. First, start early. We'll have parents come in and their kids will be like 10 and 11. They're like, I have been stressing about this in the back of my mind since I was pregnant. And here we are 11 years later, finally getting it done. They sign the paperwork, they walk out. I'm so glad that's done. It was not as hard as I thought. Why did we not do this earlier? So start planning early. Again, like I mentioned in the very beginning, we always hope that death is in the far away future, but in case it's not, having the plan now and changing it as needed over time can give you the most peace of mind. Next, involving your family if you need to in those discussions. So if you've named a family member as guardian, probably a good idea to let them know that. Make sure that they're up for the task and that they're willing to act. There may be key family members that you've named as your power of attorney or your executor, and you need them to know what to do in the event those documents need to be carried out. Now, just because they're your family doesn't mean you have to tell them your business. You got to use your judgment. You talk to the ones that you trust and you believe have the right judgment and can carry out the things that you want done. And then also reviewing and updating your plan regularly. So this is, we always recommend to people that have wills at least every 3 years. And there's nothing wrong with, when you're doing your spring cleaning, take a glance at the will and see, is everything still up to date? Other things are if you have a major life event, if you get married, if you get divorced, if you have a new child, if you start a business, if you sell a business. There's all kinds of major life events that could affect your estate plan and require it to be updated. So at minimum, set a time period where no matter what, I'm always going to look at it every X amount of years or maybe every year. And then just keep in the back of your mind, every big life event, you're going to want to review the plan to make sure it's still accurate to you. And then finally, seeking professional guidance. Like I mentioned, a person can draw their own documents. But if you're not completely confident in what you've drafted and it's just your hope to save money or, feeling like, I don't want to go to the hassle of talking to an attorney, this is one of those areas where it's too important not to be sure. So we recommend seeking professional guidance so that you can feel confident that the documents that you've got in front of you for this purpose are actually meaningful, that they actually do what you think they do. So, if we were sitting here live, this would be the time where you would ask me questions. But, the common questions I get are, how long does it take? Well, it depends on what you need. If you need a very simple will and the, powers of attorney, we're kind of on your timeline as far as how quickly you get information back to us. So from the initial consultation and you getting the intake form and answering our questions is really what's needed to kick off the process. The documents can be, in most times from the time you contact us to the end, if you are being diligent and following up with us or answering our questions, about 30 days. And really the only time you have to come to our office is to sign. If for some reason you can't sign, then, mobile notary arrangements could be available, but most people do want to come to the office to sign, and everything else can be done by phone, by video, by email to give you the most convenience possible to get this done. So that's kind of the one thing. And another thing is, how much does it cost? I'm going to say the most lawyer thing ever. It depends on what you need. So there are more cost-effective plans if money is your primary concern and spending the least amount possible. But there are plans that are more comprehensive. And of course, with that comes more expense because they're more complicated, more drafting time, more everything. If that's something that, like, before you even start the process, you want to know cost, always call your local attorney and see if you can get a cost estimate before you go too far down the path. They change, depends on the market. So, what the prices are today, they could be up higher or lower by the time you're ready to start your planning. Now, we're a real estate and estate planning law firm around the Lake Norman area, but we put out informational videos, shorter ones than this, just giving you more insight on estate planning and other matters affecting real estate. And you can find that on YouTube at The Real Estate Lawyer. You can find us on the internet at thomasandweber.com. And then, podcasts, The Real Estate Show, wherever you get your podcasts. Info at Thomas and Weber for general inquiries. And we have 3 offices around the Lake Norman area in Mooresville, Huntersville, and Denver, North Carolina. And we can help North Carolina residents with their estate plan. If you want to come and sit in our office, those are the local offices, but we're North Carolina licensed attorneys, and we can help North Carolina residents carry out their estate plan here. So hopefully you learned something today, and I gave you some peace of mind about what you need to do to plan as your children grow. Thanks.